we're going to move on to back to the news section of the program. We're going to break down the Klansman trial and things that have happened within this last week. Lots happening. So for those who were here last week, Flo had handed over their records for the 3 phones that the police have that they'd submitted in evidence. Digicel, however, had refused to do so, and the prosecutors had asked for permission from the government to serve Digicel with papers to force them to hand over the documents. However, prosecutors advised Chief Justice Brian Sykes that the package with the data has arrived in the island and is with the Police Communications and Forensic and Cyber Crimes Unit. So Digicel willingly handed over the phone records prior to them being subpoenaed and prior to them being, given a warrant for them to hand over the documents. The prosecution expressed that it had gleaned that the company was being reluctant to hand over the data, which was a part of that last week and into this week. So, they didn't end up having to use the subpoena that was issued because they were planning on issuing the subpoena on Monday evening, but the documents arrived Monday morning. The data arrived from Digicel's head office, and so that worked out for them. So now that they can submit those documents, they can compare the documents and submit it as a part of their evidence. So on Monday, a police inspector was on the witness stand, and he was in charge of the team that led the investigation into the Klansman gang case. He was unable to shed light on why the prosecution's second witness, who is a former member, was never charged. According to the senior officer who supported and supervised the investigation, the decision not to charge the ex-gangster was taken at another level. The police witness was grilled by senior counsel Lyde McFarlane about the decision during cross-examination in the Home Circuit Court. The presiding judge, Chief Justice Brian Sykes, also intervened on the attorney's behalf in a bid to get information and what he described as a great mystery surrounding the decision not to charge the ex-gangster who had confessed to being involved in serious crimes, including murders, extortion, and possession of illegal firearm and ammunition. So the judge is asking what caused him to maintain his uncharged status. Not even a caution, not even to say thank you for your information, but if you want to be in the team, you have to be charged, he asked, noting that the police must have accepted the ex-gangster's account. The judge further asked why he was not charged, even with a minor offense or charge, and given a plea deal. But the inspector said that he couldn't answer. And then when asked if his answer was if the police was refusing to answer or he was unable to answer, the police stated that the decision to not charge witness number 2 was made after he sought advice from his senior and legal team. He said that the decision not to charge witness number 2 was made at a higher level. The judge then asked the police witness if he was told about the reasons behind why witness number 2 was never charged. The police said that no, he said discussions were done about the case, but he cannot speak to the reason as to why the decision was made not to charge witness number 2. Again, the judge was pressing the police officer to try to explain why witness number 2 was free as a bird, sleeping sound at night. And he said, even today you can't shed light on it. And the officer said, that is so, my lord, I can't answer. Like, I don't know why he wasn't charged. I don't know what was the reasoning behind. Because the judge, for some reason, the judge keep pressing about why witness number 2 wasn't charged, because apparently witness number 2 did a lot. Witness number 2 confessed to murder and he confessed to having illegal guns and all of that stuff. And yet he wasn't charged with anything. It wasn't that he was charged and given a plea deal to say, okay, instead of serving 10 years, you'll serve 5 or whatever. Like, he was never charged with anything. So the inspector further admitted that when he had met and spoken with the ex-gangster, he had never cautioned him. He also agreed that he had instructed the lead investigator to take a witness statement from the ex-gangster, but denied that when he gave that instruction, a decision had already been taken to not charge the witness. According to the officer, there was no information that I had at the time to say that he was anything other than a witness, he said, according to the inspector. Initially, he was not aware that the witness was deeply involved in serious crimes. He said he found out later after reading portions of the statement. But he said, despite coming to that awareness, he said he was not the one who made the decision for him to charge. Again, the judge kept pressing because the judge is saying that he's noticing a pattern. He's presided over 3 gang trials, and in those 3 gang trials, he's noticed a pattern emerging where the witnesses that are coming forward that have stated that they've been involved in various activities within the gang. Those witnesses they're not coming coming before the court in a context where it's a plea bargain or the previous convictions or whatever. They're not getting a guilty plea. They're not getting anything. There's no consequence. He said they're just coming free as a bird, no nothing. And he's not understanding why that's happening. He's of the mind and opinion that they should be found guilty of a crime. A plea deal should be made, and then their statement or whatever, they're coming forward as crown witnesses. But so it's safe to say that the judge is a little bit perturbed that these criminals are not being charged with anything. They're just taking their statements and they're taking their willingness to be witnesses, but they're not offering them any plea agreement. So that, so the judge wants to know if that's a policy decision to be made or whatever. The detective said he doesn't know. It's just the way it is. So I think that particular issue may be looked at another time, because the judge is saying that the gang legislation is so structured where for us to be able to collect a statement treating with incidents as it relates to the activities of a gang, the best method would be for a person from the gang to come and say these things in respect to this witness. In having interviewed him, I did not go the route of caution statement and charging, the police stated. So the judge is really, really not happy that none of them are being charged with anything. And that was on Monday. And then on Tuesday, the police officer was still on the witness stand again, and he testified that cops had found an AK-47 rifle hidden in a stack of boards at a furniture shop operated by a relative of Andre Blackman, Brian, who is the reputed leader of the One Don gang. The home circuit court also heard that a magazine with 10 7.62 millimeter rounds was also found during the search in Jones Avenue, Spanish Town, St. Catherine. The police inspector who was testifying at the trial said that he was a part of a police team that went to Jonestown to arrest defendant Roel Taylor, who is Brian's cousin. According to the officer, the weapon and ammunition were found during a search of the shop that was operated by Taylor. The court was told that the shop is located a short distance away from Taylor's home. The policeman recalled that the gun was found when cops had moved a stack of boards from one side of the shop to another section. It was vertical within the stack of boards, he recollected. On seeing the weapon, the inspector said he said to Taylor, "What that under there, sir?" And he said, Taylor replied, saying, "Me don't know nothing about that, officer." The gun was made of metal and board, and the serial number was not visible. So prior to the search of the furniture shop, the court also heard that Taylor's house was searched and 5 cell phones, several SIM cards, and $265,000 were found. The court also heard that a civilian who was at the house was detained along with Taylor. The weapon and ammunition, the officer testified, were packaged in an evidence box and bags and labeled after the scene was processed by a forensic scene of crime officer and transported to his office for storage. He said it was later retrieved and taken to the government forensic laboratory for ballistic testing. He, however, recalled that the crime scene forensic officer did not detect any visible prints when checks were made. Both the weapon and the ballistic certificate were admitted as exhibits. The trial was adjourned yesterday, and their next trial date is January 10th. So I will keep you guys updated on January 10th when, they get back to doing what they're doing, and we'll see what's happening. But like I've always said, this Klansman trial, it's reading like a movie. And I'm sure at some point somebody will be making a movie out of it. So Project 876 Bro, God bless, just run across this channel. Well, thank you. Click the subscription box since you just run across us. Hopefully, what is being said here will keep you entertained and informed. We're going to move on.